The idea of a piece of legislation being a source of constitutional law sounds contradictory, but in the United Kingdom this makes sense. Usually, constitutions create institutions such as the legislature, which is then empowered to make legislation. As the constitution allows for the creation of legislation, surely it would be putting the cart before the horse to say that legislation can create the constitution, right? Well, in this video I'll break down the idea of constitutional statutes in the UK and explain how, despite sounding contradictory, constitutional statutes make sense in the UK. To understand this, we need to think of a legal system as consisting of a hierarchy or pyramid of norms. And by norms, essentially I mean rules, and not people called Norman. In most countries, the constitution is the most important source of law. So we can think of this as sitting at the top of the pyramid. And as we've said, the constitution creates the legislature, the body that is empowered to create law under the constitution. In states like the USA and Ireland, for example, this means that all legislation is a source of law underneath the constitution in this hierarchy. If there's a conflict between legislation and the constitution prevails, and the legislation is declared unconstitutional. So let's take this very simple example. Article 15.2.1 of the Irish Constitution states that the sole and exclusive power for making laws in the state is hereby vested in the Oireachtas. But the Constitution also states that the Oireachtas shall not enact any law which is in any respect repugnant to this Constitution or any provision thereof. Therefore, if the Oireachtas passes unconstitutional legislation, the courts have the power to invalidate it. This means that not only does it stop being law, it was never law to begin with. As lawyers like to say in Latin, it's void ab initio. So, as the Irish Constitution states that the Oireachtas shall not enact any law providing for the imposition of the death penalty, if the Oireachtas were to try and pass legislation reintroducing the death penalty, the courts would declare it unconstitutional. So a general rule from our hierarchy of norms is that lower order norms must be compatible with higher order norms, and so if legislation clashes with the Constitution prevails. So far so good. But what happens if norms of the same level clash with each other? For example, if two constitutional norms clash. This can happen all the time, with human rights being an excellent example of this. Imagine we have a constitution which contains the following human rights. Everybody has a right to life, and everyone has a right to free speech. But what if a person was exercising their right to free speech that was putting people's lives at risk? For example, if that person was trying to post instructions on the internet on how to make a dangerous weapon and was encouraging others to attack a minority group with this weapon. It is highly likely that a legislature would pass law criminalising such behaviour. But this legislation could be challenged in the courts on whether it was constitutional or not. A court may approach the problem in the following way. Person X's right to freedom of speech is clashing with person Y's right to life. The right to life is more important than the right to free speech, therefore the law is constitutional. From this example, we can contend that as the court has reasoned that the right to life is more important than the right to free speech, we can say that the right to life sits above the right to free speech in this instance. What this means therefore is that there can be a hierarchy of norms within norms of the same level. In our example here, we can say that there is a hierarchy of constitutional norms. Some constitutional norms are more important than others. When it comes to conflicting pieces of legislation, however, usually courts don't have to make a judgment as to which piece of legislation is more important. On the contrary, a very simple rule applies. The later statute prevails over the earlier statute. Let's imagine the legislature in 2016 passed a law called the Red Jumpers Act 2016. This law states that all people over the age of 18 must wear red jumpers in public. Fast forward to 2025 and the legislature passes the Yellow Jumpers Act 2025, stating that all people over the age of 18 must wear yellow jumpers in public. So which law should prevail? Usually Parliament would, when passing a law like the Yellow Jumpers Act 2025, include a part of the Act which states which previous pieces of legislation are hereby repealed. This is called expressly repealing. But sometimes Parliament may miss a conflict, and so courts will be required to adjudicate upon which rule prevails. In our very simple and ridiculous example here, the court will give priority to the Yellow Jumpers Act 2025 because it was passed most recently and therefore it is the best representation of parliamentary intention today. Essentially, the court is implying that the Red Jumpers Act 2016 was repealed. and we call this, amazingly enough, implied repeal. So again, the very simple rule is that the later statute prevails over the earlier statute. But because this is so simple, lawyers like to say it in Latin to sound smarter. So you will often see the rule written as lex posterior derogat priori. See, I sound much smarter when I say it like that. So let's circle back to the UK Constitution. Imagine we have a conflict between two pieces of legislation, but one piece of legislation is so important the court thinks it should take priority over other statutes, even if those statutes were passed later. This is where we get the idea of constitutional statutes. In Thoburn and Sunderland, Lord Justice Law states that we should recognise a hierarchy of Acts of Parliament, as it were, ordinary statutes and constitutional statutes. The two categories must be distinguished on a principled basis. In my opinion, a constitutional statute is one which A. conditions the legal relationship between citizen and state in some general overarching manner, or B. enlarges or diminishes the scope of what we would now regard as fundamental rights. He then goes on to give an example of some constitutional statutes. These include, but are not limited, to Magna Carta, the Bill of Rights, the Act of Union, the Reform Acts, the Human Rights Act and the Devolution Statutes. He also includes the European Communities Act 1972, which was the subject of that case. So what is the point in making the distinction between ordinary statutes and constitutional statutes? Well, Lord Justice Law states that ordinary statutes may be impliedly repealed. Constitutional statutes may not. For the repeal of a constitutional act or the abrogation of a fundamental right to be affected by statute, a court will apply this test. Is it shown that the legislature's actual, not imputed, constructive or presumed intention was to effect repeal or abrogation? I think the test could only be met by express words in the later statute, or by words so specific that the inference of an actual determination to affect the results contended for was irresistible. So simply put, constitutional statutes must be expressly repealed. They cannot be impliedly repealed. In this way, courts can give effect to a constitutional statute over an ordinary statute, even if that ordinary statute was passed after the constitutional statute. In this way, the UK Constitution can recognise a hierarchy between Acts of Parliament by stipulating that constitutional statutes are immune from being impliedly repealed. But this doesn't mean they cannot be expressly repealed, as Parliament did with the European Communities Act 1972 when giving effect to Brexit. Acts of Parliament therefore are important legal sources of the Constitution, but they are not the only legal sources, and in the next video we'll discuss how the common law is also a source of British constitutional norms.